Good afternoon and welcome to today's presentation. This will be a joint seminar, which is co-sponsored by the American Bar Association, TIPS Workers' Compensation Committee, and the Litigation and Trial Practice Committee. We're happy to have everyone with us today. My name is Zachary Rubinik. The topic we're going to be presenting today is best practices for handling complex medical issues, evidence, and witnesses in workers' compensation litigation. Just by way of brief background of myself and the speakers I have with me today, as I said, my name is Zachary Rubinik. I'm a partner with the law firm of Rowland Henderson in Philadelphia. I am a past chair of the ABA TIPS Workers' Compensation Committee and the current chair of the Litigation and Trial Practice Committee. I defend employers and their insurance carriers in workers' compensation matters in Pennsylvania and have done so for the past 25 years. So I'd like to just give you a brief introduction of our panelists today. I'll be acting as our moderator. We have Charity Lawrence. She's a member of Spillman, Thomas, and Battle in Charleston, West Virginia. Charity is the current chair of the ABA TIPS Workers' Compensation Committee, and she likewise defends employers and their insurance carriers in workers' compensation matters, occupational disease cases, and hearing loss cases throughout West Virginia, and she's done so for the past 20 years. Next, we have Thea Nanton Prasad. She's a senior attorney with Swift Curry in Atlanta, Georgia. Thea is the chair-elect for the ABA TIPS Workers' Compensation Committee. Like Charity and myself, Thea defends employers and their insurance carriers throughout Georgia in their workers' compensation litigation matters, and she's done so for 20 years. Next on our panel, we have David Deal. David is with Deal PLLC in Jacksonville, Florida. David is a longtime member of the ABA TIPS Litigation and Trial Practice Committee. David has been recognized as a top 50 trial lawyer in the United States by the National Law Journal. David is a mediator and also an adjunct professor of trial advocacy and litigation skills at the University of Miami School of Law, and he has been in that capacity for 30 years. And finally, we have Commissioner Robert Krebs. He is a commissioner with the Pennsylvania Workers' Compensation Appeal Board in Pittsburgh. Commissioner Krebs assumed that position in 2004, and he's been on the board ever since. But prior to that, Commissioner Krebs was a trial attorney and litigator in Pittsburgh for over 20 years. He is also an adjunct professor. He's with the Duquesne University Law School in Pittsburgh. So I'd like to welcome all the panelists, thank them for their time here this afternoon. And, I'd like to get started first. Charity and Thea, can you explain for our attendees, when you receive that new file referral in from your client, how do you go about recognizing the complex medical issues in the case from the outset?
All right. Good afternoon, everyone. So most of our cases, you're dealing with some underlying injury and some component of the medical. Some are more complex than others, but at the outset, the things that I want to look at, and Charity, you can jump in. What are we dealing with? What body parts are we dealing with? What type of injury was it? Are we dealing with a simple strain? Or are we dealing with something that's a little bit more complicated? Was the injury more severe? And so I want to look at identifying exactly what the injury is, how it occurred, what are the body parts that are involved, because I'm sure we see this all across the board. A lot of times what we get is injury creep. So what starts out as one thing turns into another. And at the outset, I want to get a really good idea of what type of injury it was, how it happened, and what body parts that we're dealing with.
I agree with that. And also, I like to know whether we're dealing with an actual injury or an occupational disease, because depending on whether it's an acute injury or some sort of disease that the person's claiming, like occupational pneumoconiosis, for example, those two types of issues can be handled differently.
Right. And so in terms of, I think we wanted to talk to you a little bit about is sort of discovery strategies. So what are the things that you're going to be looking for at the outset? So I'm going to be looking at the initial intake, the incident report, what was reported. Having great documentation about what happened is going to be key. So touching base with the employers and the job sites and figuring out what happened. Is there video evidence? Securing that early on. A lot of places have internal surveillance cameras on place. If you can get a video of what happened, that is going to be some of the best piece of evidence that you have going forward, because if I have a video of what happened, I can then provide that to the medical provider to give them a better understanding of how this injury occurred. A lot of the times we don't have that video evidence or video of the accident, and we're relying on primarily the claimant to describe how the incident occurred, how the injury occurred, and a lot of times it's not accurate. So if there's video, securing that early on, because sometimes these surveillance setups are not set up to record. They, after 30 days or how many ever days, they have a cycle and it gets removed. So getting that information quickly and at the outset is critical to helping to understand what's going on. Were there any witnesses? So who saw it, who was there, getting them nailed down early on to understand exactly what we're dealing with. And then also that initial treatment record. So something has happened, someone's injured, they're either likely going to go to an emergency room or an urgent care, and getting those records in quick and early is also important, because that will tell you what the person was reporting right at the time. And you can identify, okay, this person reported this was an injury to the left shoulder. There's no reference in the records to any other body parts, because if 2 months down the road, they're now saying that they injured their back, that's going to be a great starting point for establishing exactly what we're dealing with. Cherry, did you have anything to add? Sorry.
Yeah, no, just to your point too, if, you know, another important part about collecting medical records is it can show you inconsistencies in regard to, like Thea said, that what actually happened as far as the injury and what the person reported at the time. So, for example, if you have a claimant who reported on an incident report from her employer saying, you know, I hurt my shoulder trying to pull a box off a shelf on Wednesday, May 14th. But the ER record shows from that same day, she reported, well, I've been having shoulder pain for the last 2 weeks. That's going to, if from an employer's perspective and from the perspective of the attorney defending the employer, that could help you prepare a defense to argue the claim maybe should be denied or treatment should not be approved because it appears to be unrelated to a workplace injury. That's something that might be pre-existing. Alternatively, if you represent the claimant, that could signal to you, or it should signal to you, to have a serious talk with your client about her claim. And maybe, you know, if you're in the stage of litigation, to determine whether or not you should take your claimant's deposition, to, if there's some sort of reason for the inconsistency or some explanation that you want to get out there and on the record, to maybe help clarify your position. So,
yeah. And some other tools that I think you need to look at early on. So a lot of times the insurance carriers can run an ISO report, and that will show you whether there are any prior claims or injuries or incidents that come up there. And that's a great starting point for figuring out, maybe I need to request medical records from these facilities. Oh, look, this person has had an injury to this body part before, and set you on the right path for securing the documentation that you need. Another great tool that I see a lot, and some employers do this, some don't, is a post-hire medical questionnaire. We use them a lot in Georgia. I know it may vary from state to state, and I know some employment law attorneys have different feelings about the use of this, but I think it's a valuable tool for identifying prior injuries to the same body part. In Georgia, we have a defense available to us, if called a Rycroft defense, if a person fails to disclose a prior problem medical issue and then later on turns around and has an injury to that same body part, if it would make a material impact on whether they were hired or placed in that position. It's also just a great way to identify any underlying issues that the person may have. A lot of times, things that may not necessarily seem to be related to your injury can play a part. Underlying comorbidities, diabetes, hypertension, all these things play into how a person is going to recover from their injury, progress through their injury, and things that may be contributing to it depending on what's being claimed. And so those are things that I like to look for at the start of the claim. If we're now in the stage where we are in litigation, and so something is contested, now we're looking at depositions. So if I'm taking the claimant's deposition, I want to get a very thorough medical history. I want to know about any prior injuries, whether it's a work-related injury, a motor vehicle accident, or a lot of times injuries that happen outside of work or outside of the context of a claim. People that play sports, I love to ask questions about, do you play any sports? Did you play any sports in your youth? Have you had any prior injuries that required medical intervention, prior surgeries? All the information that you can gather to determine what this person's prior medical history looks like. Identifying the primary care physician is also key. The primary care physician records are great for identifying all sorts of things that are going on medically with a person that may not necessarily jump out at you at the outset of a claim. Pharmacy records, what type of medications is this person taking? Do they have a history of taking narcotics or opioid medications? That may be a signal that there's some prior injury there, some prior medical issue that's required ongoing use of that sort of medication. And then those pharmacy records are also a great place to identify other providers that you can request records from. Depending on the complexity of your issue, if we are talking about a complex medical issue and it's litigated and there's a dispute, sometimes a good doctor's deposition is going to help you with your defense of the case, because sometimes we're getting into these issues where it's a really narrow medical issue that can be really difficult for the judges to ascertain exactly what's going on and why this particular piece of information is important or valuable. If you can nail down the doctor in sworn testimony through deposition, that's going to be very helpful. I used to do a lot of doctors' depositions. I don't do them as much as I used to, but in a complex case, I think it's a really, really valuable tool for getting the court to understand exactly what the complex medical issues are.
Charity and Thea, let me ask you, occasionally discovery disputes arise among attorneys when you're seeking records. How do you address whether it's a specific discovery request, a specific record, an objection to a subpoena? How would you handle those issues during the litigation phase?
Thea, I'll let you handle that one.
Sure. So I'm sure this varies a little bit from state to state, but in Georgia, we are entitled to medical records that are likely for conditions that are likely related to or attributable to what's being claimed. A lot of times when we get an objection, it's because the other side thinks that we're going beyond the scope of what's permissible. But the way our statute is worded, it does allow you some wiggle room in terms of the scope of records that you can get. I don't know whether the medical record from the primary care physician addresses the injury that we're dealing with or not, but there's also an argument that it doesn't necessarily have to be just about your injury. It can be something that is contributing to that.
Mm-hmm.
And so sometimes we'll get into a motions argument about it. So someone will file a motion to say, no, we do not want you to be able to access these records, and we'll handle it that way by motion. Sometimes it becomes a litigated issue. A lot of the times, though, the issue will get worked out prior to having to formally go to a hearing, typically gets resolved through a motions type of argument, or in Georgia, we have a process where we can do a sort of informal petition before the judge to address medical issues, and that has been a useful tool for sorting out some of these things. But generally, the idea is that we are supposed to be able, through this discovery process, to do just that, to discover the records that may be relevant and the things that are related and possibly not related to the claim. Sometimes it's not worth a fight. Sometimes we get into issues about not wanting to reveal psych records and things like that. And in those circumstances, sometimes what we will ask for is sort of a redaction of the records so that we're not accessing the information that we really don't need. But generally speaking, I do not like to just agree that, no, we're not going to get the records from this particular provider because I don't really know what's in there. And if it really came down to it, we could request an in-camera inspection of the records to alleviate whatever the concerns may be. I haven't often had to take it to that level, but that is another tool for trying to get the information that you need, because you really don't know what's in there until you have the records.
Yeah, I agree with that. And in West Virginia, we actually don't have that many disputes about that issue, because typically our medical releases that we send out for claimants to sign, we try to tailor them to specifically reflect not only the specific injury that they've alleged, but we try to encompass the other types of things that we've seen in their maybe medical records that we already had, or what is on their initial form indicating an injury. So if they just, because sometimes, those forms can be, their injury description can be so vague. It can be, shoulder, and I hurt my shoulder and neck. Well, okay, so we want anything dealing with the cervical spine, the shoulder, anything in that type of area. That usually does not get any objections. Also, if we tailor the span of how many years we're looking for records for. So usually, if we were to ask for like the past 30 years worth of records, that would probably garner an objection. We probably wouldn't win on that issue. But if we ask for records from the past 10 years prior to the accident, that's usually something that, at least in West Virginia, would not be objectionable. So we typically don't have many disputes in discovery in that regard. I think maybe it's just because we're such a small bar and we have we know the personalities on both sides, and we know what's going to get an objection and what's not, and what we really need. But like Thea said, you don't know what you don't know. So you don't really know if there's a record, that's out there from a provider that you wouldn't typically have sought records from, that maybe has something that would be useful in it for your case. So it's kind of a tough situation, but we've tried to figure out how to navigate it with tailoring our releases.
And Charity and Thea, in addition to the medical records and the discovery process, talk a little bit about the importance of obtaining the criminal background search. The ISO search is so important. The investigative reports, the social media reports, and especially surveillance. And it's ironic, since we've started, I received an email from a client and said, "Hey, Zach, check out this surveillance. Let me know what you think." How important are those things in your preparation for litigating your case?
And it's very important. I mean, if you have, for example, this has happened with us, a claimant who says that they can't work, that their back has been injured so bad, they can't do anything, they can't participate in their hobbies or whatever. Sometimes these people will have pictures or videos on their Facebook of them participating in activities that they shouldn't be able to participate in based on the injuries they've described. So that's if you can get access to that, like social media type information, it can be very useful. And I love a good surveillance video. If as an attorney for the employer, I've had a few of those that have been just smoking guns, and that's always interesting to receive, and it's pretty convincing evidence to submit to a judge for a determination about an injury. So I fully believe in turning over every stone possible and finding out criminal background, prior accidents, prior injuries, social media postings, if you can. It's useful.
Yeah, absolutely. Any information about prior activities or current activities. A lot of times the surveillance is helpful in the middle of the claim where you have someone that's repeatedly telling the doctor, oh, I can't get out of bed, I can barely move, I can't do these things. And then you have them on video doing just the opposite of that. I actually had an interesting case the other day where it wasn't so much the activity that the person was doing, but we found out that the person was running their own HVAC business while contending that they couldn't work for our HVAC business where he got hurt. And so, you know, there are so many angles and things that you can find out through, and it started out with a social media search, which showed that he had, you know, they found the company's website and all these things. And so, you know, that's information that helped us to bring the claim to conclusion, because he was clearly capable of doing more than he was indicating that he was, and, you know, was earning income while collecting workers' compensation benefits. The bankruptcy records was the other thing. Bankruptcy records are great because a lot of times when people go into bankruptcy, it's unfortunately because of medical debt. But if someone has a bankruptcy on their record, it will reflect who the debtors are. And if there is a significant amount of medical providers listed there, that's a clue to you that this person has had some sort of significant medical event previously. And so it's another way of determining, you know, what was going on before this, what's the history there, and a clue to more medical providers that you can request records for.
And I mean, would you both agree? I mean, as attorneys representing employers and their insurance carriers, I mean, our goal is to gain leverage, and as much leverage as we can during the discovery phase to set up the trial process and ultimately the settlement negotiations phase.
Absolutely. I mean, the more evidence, and really for both sides, the more evidence you can gather, especially through medical records, for example, depending on whether you represent the employer or the claimant, the medical records themselves will open up a whole treasure trove of information about a claimant that you wouldn't otherwise know, or that there would be no other access to that information other than medical records. And I think that it's important to you know, try every avenue of discovery and collecting medical records and looking at social media and, you know, getting those ISO searches to set yourself up for, or to at least know what you're going into when you're in litigation. You could find out maybe what points you should concede based on the things that you discover about a person's prior, you know, pre-existing conditions, or the things that you should really hammer home to, you know, depending on which side you're on.
So now we've completed the discovery phase, and we're going to transition into the trial phase. David, can you take us through how you utilize what you've uncovered in the discovery phase and how you prepare your witnesses and prepare for whether it's a live trial or a virtual trial moving into that trial phase?
Okay, I'd like to say, can everyone hear me all right?
Yes.
Okay, great. I'd like to say that, you know, we're now kind of in more of a virtual world, and I've tried a couple. I tried a federal bench trial all by Zoom. I tried one in state court. And so I learned a few things from that, and things have changed quite a bit, but I used to always prepare my witnesses in person whenever possible. And I would try to, you know, make them be comfortable and make sure that, you know, they were ready to testify by covering everything. I find that in the Zoom world, there are some tremendous advantages. Like I used to drive for hours sometimes to a doctor's meeting, and then I'd get there. This is before the days of cell phone, and they'd say, "Oh, you didn't know we called your office. We canceled this 2 hours ago." You know, so you don't have that kind of wasted time. But I do find that you need more time in these Zoom preparation sessions with physicians and witnesses to get them ready. And you know, presentation does make a huge difference in terms of the quality of the presentation of your evidence and the effectiveness of it and getting the result you want. So, the first thing that I'll echo what Charity and Thea said, you have to really be very thorough in reviewing everything. I've spent an awful lot of time with medical records over the years. I've been on all different sides of litigation, although I haven't been involved in too much comp litigation. But it's been my experience that you can learn so much from medical records and follow up on that and relate to that. So I understand some insurers and they put the squeeze on defense expenses, say, oh, we don't want lawyers to look at medical records. Let your paralegals do that. But I don't agree with that at all. I think you need to be thoroughly prepared. And judges, the main thing when they're trying to decide a case, they're looking to credibility as well as the factual information related to the legal issues. And so if you've done your homework and you're really prepared, the judges notice it and they talk to each other too. And they say, oh, that Thea, she's really always prepared. I mean, you can tell that she really knows her stuff and she's gone through these records. Makes a huge difference. So I think it's very important when you work with witnesses. Also, give them the time to study the documents that are related. You don't need to use every document with them, just the key ones, but make sure they're ready to go with the documents and they're ready to go with the testimony. But even with all of that, you never know what happens in trial. Sometimes very sophisticated witnesses can say absolutely the wrong thing, and then you have to land on your feet and see what you can do.
And David, that's a great point. I have a question here to ask you. How, you're a trial attorney, but you're also a professor. How do you prepare not only your students coming into the legal profession, but also, younger associates to deal with those unexpected things that occur during the trial?
I think you can, in teaching students, I've been teaching law students actually for up to 35 years now. And there's a lot of information you give them that when they're in law school, it goes in one ear and out the other, and they don't always pay attention to it. But one of the greatest satisfactions for me has been when I'm in the courthouse, like the courthouse behind me. Do you see the photos in my background? I have different backgrounds depending on what court I'm in when I do a depo or have a hearing. But when I'm in the lobby of that courthouse and someone comes up to me and says, oh, Professor Deal, oh man, I didn't realize it when I was in law school, but you were such a great professor. All those things you said to me have resonated with me years later. So you try to let them know, but there's just a lot of things that even the best preparation doesn't really prepare you for. You have to live through them, and they're painful and you learn from them, but I think it's really the general quality of your preparation. When I was a young lawyer, I was at a law firm called Floyd Pearson Stewart, Richmond, Greer, and Weil, and we had our own video set up with these black and white videotapes, and some of our senior partners had given some lectures to us for internal use. And one of the messages that Larry Stewart said was, you have to take the spear, if something bad happens in trial, you take the spear and act like it's nothing. And then the jury or the fact finder will look at you and say, well, if Deal thinks it's nothing, well, maybe it is nothing. So you have to be prepared for the unexpected. And when it happens, just stay focused almost robotically and just go on to your next point, stick with your theme, stick with what you're doing. And if you don't overreact to it, oftentimes it doesn't have as much an effect as you might think otherwise.
And oftentimes, there can be surprises that occur during a medical expert deposition. Perhaps a document or a medical record that was not previously discussed in your preparation meeting. How do you work with the witness to deal with that, and if necessary, rehabilitate that witness's opinion on a particular document or diagnosis or diagnostic study, for example?
Well, if it's your witness, okay, as opposed to, when you're taking a depo of the other side, but it's your witness, you can prepare them. In Florida, there's some ethical and privacy concerns. We can't just go calling up a doctor and say, hey, you represented the plaintiff, I'm on the insurance company side of this, let's chat. They used to do that some, but I think some of the case law prohibited it without, a proper release and circumstances. But so what you do is just like any other witnesses, you prepare them in great detail. and you have them testify from what they know, and you go through the records with them and over again. I had one case where I spent 40 hours preparing the physician to testify, and it needed it. He was a great doctor and a great investor too. He did very well for himself, but he did not come across well. So you just make it easy for him, and kind of what you say is on direct examination, just listen to the questions, answer the questions. Please try not to, you hold up your watch or whatever, and you say, don't, reinvent the watch, or, tell us how long the battery has left on it, but just, answer the questions basically. But in cross, kind of go with me. So if I'm cross-examining you, just kind of roll with the flow. But on direct, just answer the questions. And I find that works pretty well. It's the same method for any witness, but it's really time and respect. If you learn about your witness, if it's a doctor, find out about their training. Where did they train? What did they do? What's important to them? Ask in the community about them. And when that doctor, particularly in a medical setting, when a doctor knows, I think that's very helpful. Also, you want to focus on simple language. I used to lecture at the University of Miami Medical School on medical legal issues, and it was amazing how first-year med students could suddenly start using very much difficult, technical language that the average person wouldn't understand. So you go through with them how you can explain it simply so that everybody understands it. And I think that does yield benefits when a surprise happens. But sometimes you just have to hope that they'll land on their feet. And, having been through that, I'm sure every experienced lawyer has been through a few wildly surprising, disappointing things that a witness says that you never thought they would say. And you just find a way to just, get back on your topic.
Talk a little bit about for us, we've had experience of being in the room where it happens, where the depositions occur. You have the medical expert and counsel and stenographers, and you had exhibits where you would hand them across the table. They'd be identified, they'd be reviewed, they'd be questioned. Now we're in the virtual world, and many medical experts are being deposed virtually. How do you prepare for those types of depositions with the oftentimes voluminous medical records or medical exhibits you may have?
Well, it's much harder when you're not there in person. That bench trial, the Federal Tort Claims Act I was telling you about, I had a witness who was really very good, and I was one of the first lawyers to use him. He was one of the first MRI doctors that knew how to analyze those. And so it just took a lot of time. So what I do is I physically deliver to them binders with nice tabs and nice labels on them, so they can see when I'm across, if I'm prepping them through Zoom, they can see exactly what I want them to see. And you highlight the key things, and you have the binders very accessible to them. But I find that it takes, in my estimation, sometimes as much as 5 times as much time to prep a witness with Zoom than it does in person. And so it costs money, it's effort, but you just have to go through the things and practice with them. And then usually it goes pretty well. But one of the key things is really is lighting, believe it or not. So a lot of times these expert witnesses, they make legal things are a low priority for them. So they'll make time for you, but they may be in the wrong place, or their clothes aren't good, or the lighting is behind them. I've had it where they have an office right near a major road, and you hear the trucks rumbling in the background, boom, 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 the sounds, and you can barely hear what they're saying. Also, one of the things I do with witnesses is I practice for them to have a courtroom voice if they're in court, but also in Zoom, they have to keep their voice level up, speak clearly. One of the things I've done with my law students over many years is I'll have them come outside. At the University of Miami, we have a big courtyard with a fountain with some sound of water coming down and beautiful tropical plants and such. I have them come out on these walkways and have a conversation at 30 or 40 feet with a fellow classmate. Just simple stuff. What is your name? Okay, my name is Thea Nathan Purcell. Okay, could you please tell me a little bit about yourself? And I have them slow it down. Law students' minds work very rapidly. Same thing with doctors. their minds are spinning ahead, and you need to kind of quiet down their minds so they can communicate more clearly. And I've been involved with prepping judges for appellate judgeships. Similar tactics apply, in terms of getting them to slow it down, take their time, use simple language, and focus and explain. I think what helps a lot in a case is explain your motivation, like who your client is and why it's important to you and why they have an important role. And if you make them feel important and you show them a lot of respect, they tend to do a better job. So those are a few observations.
And I think that's important because that goes to I'll call it courtroom management. There are different skills which we utilize when we're trying a case in person versus trying a case virtually. And, it's interesting. And we were together recently and had dinner, and we're talking with some younger lawyers and law students. And many of those, David, have not had the opportunity to be in a live courtroom yet since the COVID pandemic. I mean, how do you work with, train, and assist those younger lawyers as they move into the legal profession?
I think you need to make statements that'll sink in with them. Like, how many of you have heard that expression, possession is 90% of the law, or something like that? That's a kind of a common expression. But another is to say position is 90% of trial success. And in a courtroom, you have those positions. So when I'm on direct exam, I'm invisible. I want to be back, in the courtroom. I want to be back by the jury box. So they're not really hearing much from me. I let my witnesses tell the story and connect with eye contact with the jury. Same thing with videos. Positioning is important. I mentioned lighting, also audio. Sometimes witnesses call in from a phone in a car, and it's difficult and awkward to handle. But you want to try to prepare so that doesn't happen, but sometimes emergencies occur. So one of the most important things is to let them know where practice with them, where the camera is. Look right in the camera. And in person, you can stand behind the camera and practice with them because they're looking at you, and your eyes and the camera are not very far apart. And I was sort of a pioneer on video depots, believe it or not, many years ago. And that's one of the things I did with the witnesses is I had them, where the distance from my eyes to the camera were as close as possible. I would even hover over the camera in video depots of expert witnesses or others to prepare out for testimony outside of the state when you'd show it back. So that's one of the things to talk about is that it's all about the presentation. One of the things I often mention is paintings in museums. There's a lot of back in early days of Christianity, they had kind of a two-dimensional Christ figure, photos like Byzantine and even before. And the ancient Greek photos, a lot of them were not three-dimensional. But the interesting thing is when they look at you from a painting, you could be standing here or there, and it looks like they're looking right at you. So when you explain the importance of looking into the camera and explain that you're looking into the eyes and the souls of the jurors or the judge, it helps them a lot in trying to discipline themselves to look at that camera. Look straight into that lens in a way that they can connect with the jury. Because one of the things I also explain is that jurors think, that if someone's looking them straight in the eye, they're telling the truth. Now, they may not be, and there are good liars, particularly that'll look someone straight in the eye and they'll say anything. They'll say, Zach, boy, you've got a really thick head of black hair. And I'll practice with them and I'll say, see, even when you're saying something clearly not true, it comes across as more credible when someone looks right into the eye of the juror or the judge involved. So that's another example of preparing. But it's very difficult, truly, Zachary, in a Zoom world to develop the types of techniques for live hearings as well as for Zoom that are effective for young lawyers. And a lot of young lawyers aren't even doing depots in person, so they have none of that. And they don't see judges in motion calendars anymore. That's all by Zoom. So you try to teach the tricks of Zoom. In that case, for example, what if the judge doesn't have a camera on them, and you can't get their reaction to what's happening. Well, you have to have the guts to say, Judge, I'd really like to be able to see your face during the hearing, because sometimes they'll be in the paperwork and they'll be looking down and you can't tell how they're reacting. And say, it can help me move this thing along a little bit more if I can see, if I can tell if you're uncomfortable for some reason, I'm repeating myself. I don't want to do that. So can we make sure that we have, your camera setting in a way that I can see how you're reacting? And sometimes you can do it with the JA, the judge's assistant, or the clerk of the court, or the bailiff, anybody. But try to get them on that camera or you got a problem. Another thing is dirty tricks. The other side, sometimes they'll ask a question in a way that, particularly if it's a hybrid where one's in the courtroom and one's on video, where they're like mumbling and you can't hear the question to object to it. So there's so many things to learn from that. But with young lawyers, I think the key is to focus on, the screen, like the positioning of the head. I used to call it the Dan Rather. I don't know who knows Dan Rather anymore, but look on network news, or Fox or MSNBC or whoever you look, CNN, look at how they zoom in, slowly move back and forth, and how much the face fills the camera. I mean, you don't want to go too far where it's like some examination of their nostrils, but you want to make the point of being in a position where they're filling the image with most of their face so that the jury and the judge can read them. But again, it's not easy, and I don't know that there's any perfect solution to this, but new law schools are trying to deal with this more, but it's an ongoing challenge. We have a new law school in Jacksonville, and Nick Allard is our dean, and he's terrific, and he's trying to teach the students along the way so they're ready to go, even though they don't have as much in person. But his law school is right across the street from the courthouse, so he's going to try to have them go in to see more trials like I did when I was a young lawyer. I went and saw the best lawyers I could and saw the most trials I could to learn from that. Well, now I think it's even more important that young lawyers and law students get in there or get online. You can, call the judge's office and be able to come in on a hearing, like a motion calendar. They can just, click in and watch it and observe and, try to pay attention to what seems to work and what doesn't work.
And this may be obvious, but I mean, how essential is it that, the attorneys be familiar with and know the rules of the court that they're practicing in front of? Certain things are permissible with certain judges and certain things are not. And that could sideways your preparation in your trial immediately.
You need to ask around. I mean, in Miami, it was easy for me for many years because I kind of knew most all the judges pretty well. And there are certain lawyers that are in court more than others. You pick up the phone and you say, hey, Jane, what's it like when you're in front of, this judge? And they'll tell you. I mean, some judges tend to decide things on whoever argues first. Other judges tend to decide on who argues last or something in between. The best judges listen to everything, hopefully, and try to evaluate things. But one thing that's important for them to know is, if they don't know the local rules and the judge starts to get upset with them, chances are, even if they have a winning argument, it may be rejected because the judge is just sick of them and they're wasting their time and they're boring them. So all of that, relates not just to the rules that are available on the judge's website, but many of the judges have websites and they have like a local rule. It's not like a rule of civil procedure or a rule of judicial administration, but that's a good thing to read also are the administrative orders of the court you're in front of. I mean, if you really want to take your time, you do that. But knowing those rules, Zachary, is so important. I had a very famous lawyer named Bob Montgomery bring me in to try some cases with him in Miami. And he was like in his 70s, and unfortunately he died, I think, about 75, but he was like the main tobacco lawyer for Florida, and he did extremely well for himself. And he was in this jury trial with me, and I was kind of the lead lawyer, and I'm looking over at him, and he's got the federal rules, and he's reading the commentary on the bottom of the federal rules at that stage of his career. So that shows you how a great lawyer knows how important it is to know the ins and outs of the procedural rules.
Now, Commissioner Krebs, we've completed the discovery phase. The evidence has been presented to the trier of fact. A decision has been rendered, and one side is unhappy and files the appeal. Can you walk us through the considerations that the appeal boards review when they're going through the appeals that are filed by the practitioners.
Sure. Let's go to the next slide. Okay, so complex cases are like any other case. You know, I was a trial attorney for 20 years, and then I've been on the bench for 20 years. I can't say which is worse, but you know, on appeal, I've heard it said that after the trial, the appellate process is after the battle is over, we come in and shoot the wounded. We're looking at the record below.
I mean, shoot the survivor.
Shoot the wounded. Is there evidence to support your case? The golden rule: if it's not in the record, it doesn't exist. And that means getting all your evidence in, getting all your exhibits in, reminding the judge if something was not admitted at trial, you know, get that record corrected while you're still in front of the trial judge. Because we can't look at it if it's not there. Next slide, please. Okay, with medical cases, or with any case, are there any hearsay problems? Although the rules of evidence, you know, allow a doctor to rely on records. Doctor, will it refresh your recollection if you look at these records? Yes, it would. Okay, please proceed. So they can look at records such as tests, x-rays, medical histories, and forming an opinion. However, that's not the same as relying on an opinion to form an opinion. We ran into a situation where we had too many layers of opinion evidence built to support the opinion, where we just had the one doctor at the end of the chain testifying. And there's a question as to, well, was the doctor who was testifying, what was he forming his opinion on? And the basic rule of thumb is, look, if you're in doubt, have the witness testify in order to avoid having any hearsay problems where you've built a house of cards that might get knocked down. Next slide, please. All right. So if you are the party with the burden of proof, there must be an opinion on causation, okay? Causation must be established within a reasonable degree of medical certainty. In occupational disease cases, there may be a presumption of causation for certain conditions that are endemic to a particular industry, such as asbestosis, black lung, silicosis, hepatitis for some first responders. Some jurisdictions have created presumptions for COVID-19 for first responders and medical providers. That's great if you are in a jurisdiction like that. The problems we have seen are people who were not under that special carve out for first responders or medical providers, but yet had contracted COVID-19 with a very strong argument that they got it at work. The problem we ran into in Pennsylvania, we have a catch-all provision where, look, if the legislature hasn't thought of every possible occupational disease, if you can show that you are in an industry where the disease is more prevalent than that of the general public, you too can get the occupational disease presumption. The problem we had was COVID was such a new disease that there wasn't any literature or argument to say that it was more prevalent in a particular occupation than the general public. The one case we did see somebody win who wasn't a first responder or medical provider had to do it by direct evidence. His argument was, well, I'm a prison guard and I go into this contained facility every day. Only people who are in there are the people who are in the prison. And then I come home, and because I have no life, I never go out. And there he was able to win on direct causation. The judge found that credible, but he was not able to win on a occupational disease presumption because he couldn't show that COVID-19 was more prevalent in the prison industry than it was in the general public because we didn't have the information. Next slide, please. All right. Finally, were the necessary credibility determinations made below regarding the witnesses? Pennsylvania, where I've practiced and judged, follows the minority rule where the findings made by the workers' compensation judge or the hearing officer, whoever your first level trial judge is, are final if they're supported by substantial competent evidence. Therefore, credibility findings are binding on appeal unless they are arbitrary and capricious, okay? Other jurisdictions I recognize, though, allow for new determinations to be made by your administrative appeal body, be it the Industrial Commission in Ohio or the commissioners in other states. And so there you might be fighting a credibility war at the appellate level. And so it's really important that you establish the credibility of your client below. You know, it was funny, there previously, attorneys Lawrence and Nanton Passat were talking about things like, does the claimant play sports? And one of the things I tell my law students is they're reading the book, and yes, they're reading a book that I put together of cases that I either tried or adjudicated or the court above me adjudicated. And I always tell them that in their hearing loss cases, you ask the client, do you hunt or fish? And your hearing loss case, it's always going to be a guy who belongs to a gun club and is out skeet shooting every week. Or, sir, we're in the military. Yes, what branch? Artillery. Why is it that every case of hearing loss you have, the guy's either a gun club member or served in the artillery? Well, because those are the cases that get tried. If you have a guy who had no life other than working in the factory where they're hammering metal together all the time, that case probably settled. Likewise, on your occupational disease cases, the heart and lung type injuries, your client is always going to be a smoker. Why is that? Because those are the cases that get tried, that the defense has something to work with. All right. Next slide, please. All right. Although credibility findings in some jurisdictions may not be subject to challenge on appeal, competency of the medical witness or any witness is reviewable as a matter of law. Now, of course, the standard to qualify as an expert witness is not particularly demanding. Does the witness have any information, science, background, training, experience that can be helpful? But you do have competency issues. And where we run into them is where you might have somebody who's a medical provider, but not of the same specialty or not have the same specialty training in order to testify in a very specialized area. So those are things we're looking at that are something that can be challenged on appeal. We also have a situation in Pennsylvania where if the recognized injury below, be it adjudicated by the trial judge or agreed to in a notice of compensation payable by the defendant, if that's established, but now we're in a termination situation where they're trying to say he's fully recovered, that medical expert had better be willing to say, yes, he had a herniated disc at L5-S1, but I believe he has recovered. The problem we run into is, let's face it, we're lawyers, they're scientists. And so you might have a doctor saying, well, he never had a herniated disc at L5-S1. And that has been held by our Court of Appeals to be incompetent testimony. If the doctor doesn't recognize the established injury in giving an opinion that the claimant is recovered, that has been thrown out. And so the way you have to fix that is, doctor, has the claimant recovered from the herniated disc at L5S1? Well, he never had one. Understand that, doctor, but it was found below that he did have one. Do you have an opinion as to whether or not he has recovered from it? Well, he's never had one. All right, doctor, assuming he had a herniated disc at L5S1, do you have an opinion within a reasonable degree of medical certainty as to whether he has recovered from it? Yes, assuming he had one, I have an opinion, and that is he has recovered from the herniated disc at L5S1. So those are just some issues that we see in competency. I would like to move on now to talk a little bit about briefs and motions, if you will. And that is, yes, we've talked about competency. So I'm now going to talk, yes, you can close off my, yes, and just go back to people. Yes, okay. Briefs and motions. On motions, get to the point. Judges have limited time, they have limited attention span, and they don't want to wade through pages and pages on a simple motion or minutes and minutes of argument. Get to the point. Tell me the reason why I should rule for you from a legal standpoint, okay? I don't need to hear that this is the greatest travesty in American jurisprudence ever, because everybody who's in court is there because something has gone wrong. Likewise, the briefs. You've got to consider candor to the tribunal, okay? You cannot play fast and loose with the law or the facts. Why? Well, either I will catch it, or my law clerk will catch it, or scarier yet, opposing counsel will catch it and proceed to beat you over the head with it. And so there are too many eyes on what's going on, calling you on stuff. So, like I would have to say, candor, recognize where your argument is weak. Go with the argument that is strong. As far as oral argument goes, be prepared. Oral argument makes a difference. There have been times where I've read the briefs, I've read the motions, I've made an opinion in my head, and then I've had it explained to me by counsel in a concise, direct way, and it has made all the difference. It's caused me to rule the other way. What do we hate on appeal? We hate, this wasn't my case at trial. Counsel, it wasn't my case at trial either, but if you're here arguing in front of me, it is your case, and here we are. If you are arguing the case, it is yours, and we expect you to be prepared. And now, we realize in complex cases, or in any case, you're going to have a lengthy record. And we will ask you questions, and there may be something you don't know. The best answer is, Your Honor, I'm not familiar with that. I'm not prepared to answer that. It's in our brief, or I'm sure it's in the record. But, don't say, I didn't try it below, because that's only going to infuriate us. Saying, I can't recall, that's fine. We're all human. With that, I would like to echo what was said previously by David Deal. Know the rules. Knowing the rules of court is going to buy you a lot of credibility with the judge, either at the trial level or the appellate level. And know the judge's rules. Know how they want to do exhibits. Do they want them numbered in advance? Do they want you and your opponent to have stipulated to everything in advance? So to minimize objections at trial, or at least narrow them. Knowing the rules will make you a better lawyer and a worthy advocate. Thank you.
Commissioner, I had a question for you. One thing I think many lawyers either fail to recognize or or they choose not to, is that, the appellate boards, you have the briefs, you have the evidence, you've read the appellate argument. And I think you made a great point. Just get to the point of the argument, whether it's a substantial competent evidence argument, whether it's an error of law argument, whether it's a reasoned decision argument. I think it's so important to point the appellate board to your specific argument, the specific error, the specific case. And if there's a case that is against you, differentiate that case from the facts of your own case. Would you tend to agree?
I would agree. And this is such a basic thing. And yet, for as basic as it is, lawyers miss it all the time. Tell me the relief you're seeking. Do you want it remanded for a factual finding or credibility determination? Do you want it outright reversed? Do you want it modified as to the average weekly wage or period of disability? If you're coming before the appellate bench, you are seeking relief, and you must know the relief you're seeking.
Okay. Well, thank you very much. I'd like to thank all of our panelists. We are at our 2 o'clock 1 hour mark Eastern time. So I would like to thank you all for your time and participation. And I'd like to thank the ABA for supporting both the Workers' Compensation Committee and the Litigation Trial Practice Committee. Thank you and have a nice day, everyone.
Thanks, Zachary.
you.
Thanks, everybody.